Okay, tapos na rin naman yung sulod. Pag sa sulod, tama na ako ha? Backward, forward, oh? Pasulod, pagwa. Pasulod, pagwa. Tapos, pagdali na naman yung hipon, pasulod, pagwa. Kita nyo? Kita? No? Pasulod, pagwa, ha? Pasulod, pagwa.
Nelson Mandela once said, "There can be no keener revelation of a society's soul than the way in which it treats its children." Children are the future, a future brimming with hope for a better world, a future we must protect, which is why in 1992, Congress pushed for the passing of Republic Act 7610, otherwise known as an act providing for stronger deterrence and special protection against child abuse, exploitation and discrimination, and for other purposes. The law was passed in order to provide for special protection to children from conditions prejudicial to their development, provide punishments for violations, rehabilitate victims, and intervene on behalf of the victims. Before we get into the law itself, let's take a moment to understand what some of these terms mean. First up is the term children. As we all know, the word children refers to people under the age of 18. Republic Act 7610, however, recognizes that some people over the age of 18 are just as vulnerable to abuse as children. As such, the word children also extends to persons unable to fully take care of themselves or protect themselves from abuse, neglect, cruelty, exploitation, or discrimination because of a physical or mental disability or condition. The next term we need to tackle is child abuse. This term refers to maltreatment of children, which includes any of the following. Number 1. Psychological and physical abuse, neglect, cruelty, sexual abuse, and emotional maltreatment. Number 2. Any act by deeds or words which debases, degrades, or demeans the intrinsic worth and dignity of a child as a human being. Number 3. Unreasonable deprivation of his basic needs for survival. Number 4. Failure to immediately give medical treatment to an injured child, resulting in serious impairment of his growth and development, or in his permanent incapacity or death. Keep in mind that child abuse does not have to be habitual. One instance is enough to warrant a violation. The third term we need to understand is circumstances which gravely threaten or endanger the survival and normal development of children. These fall into 4 major categories. Number 1. Being in a community affected by armed conflict. Number 2. Working under conditions hazardous to life, safety, and normal development. Number 3. Living in or fending for themselves in the streets of urban or rural areas without the care of parents or a guardian, or basic services needed for a good quality of life. Number 4. Being a member of an indigenous cultural community and or living under conditions of extreme poverty or in an area which is underdeveloped and or lacks or has inadequate access to basic services needed for a good quality of life. Number 5. Being a victim of a man-made or natural disaster or calamity. Number 6. Circumstances analogous to those above stated which endanger the life, safety, or normal development of children. Finally, we have comprehensive program against child abuse, exploitation, and discrimination, which refers to coordinated programs which prevent. Number 1. Child prostitution and other sexual abuse. Number 2. Child trafficking. Number 3. Obscene publications and indecent shows. Number 4. Other acts of abuses. And number 5. Circumstances which threaten or endanger the survival and normal development of children. Article 3. Child prostitution and sexual abuse. Children are deemed to have been sexually exploited when they, upon coercion or influence of any adult, perform sexual intercourse or lascivious acts for money, profit, or any other consideration. There are 3 types of violators within this article. These 3 are: Number 1. People who engage, promote, facilitate, and induce child prostitution. Number 2. Those who have sex or commit lascivious acts with an exploited child. Number 3. And anyone who derives profit from the exploitation. The penalty of reclusion temporal in its medium period to reclusion perpetua shall be imposed on these violators. Article 4. Child trafficking. People are liable for child trafficking when they engage in trading and dealing with children, including, but not limited to, the act of buying and selling of a child for money or for any other consideration or barter. Violators will also be held liable for attempting to traffic a child. It is assumed that an attempt was made when a. When a child travels alone to a foreign country without valid reason therefor and without clearance issued by the Department of Social Welfare and Development, or written permit or justification from the child's parents or legal guardian. B. When a person, agency, establishment, or child-caring institution recruits women or couples to bear children for the purpose of child trafficking. C. When a doctor, hospital, or clinic official, or employee, nurse, midwife, local civil registrar, or any other person simulates birth for the purpose of child trafficking. D. When a person engages in the act of finding children among low-income families, hospitals, clinics, nurseries, daycare centers, or other child-during institutions who can be offered for the purpose of child trafficking. Violators shall suffer the penalty of reclusión temporal to reclusión perpetua. The penalty shall be imposed in its maximum period when the victim is under 12 years of age. Those guilty of attempt will face the same punishment but imposed 2 degrees lower. Article 5. Obscene publications and indecent shows. A person is liable when they are involved in having a child perform in obscene exhibitions and indecent shows, whether live or in video, or model in obscene publications or pornographic materials, or to sell or distribute the said materials. Violators shall suffer the penalty of prisión mayor in its medium period, with the maximum being imposed if the victim is under 12 years old. The guardian of the child that allows or causes this exploitation shall also be punished with prisión mayor in its medium period. Article 6. Other acts of abuse. These acts consist of any other acts of child abuse, cruelty, or exploitation, or to be responsible for other conditions prejudicial to the child's development. Any person who keeps a minor who is 12 years and under or 10 years younger in a private hotel, beer joint, spa, or other similar establishments, unless related within the 4th degree of consanguinity or affinity, or any bond recognized by law, local custom, and tradition, or acts in the performance of a social, moral, or legal duty. Any person who shall induce, deliver, or offer a minor to any one prohibited by this act to keep or have in his company a minor. Any person, owner, manager, or one entrusted with the operation of any public or private place of accommodation who allows any person to take along a minor under the circumstances previously listed. Any person who coerces street children to beg for a living or coerces them to take part in illegal acts. Article 7. Sanctions for establishments or enterprises. This provision states that all establishments deemed to have any participation in the illegal acts under this law are to be closed, have their licenses removed, and their managers or owners prosecuted. Article 8. Working children. Children below 15 years of age may work when: Number 1. Under the sole supervision of their parent or guardian without danger and provided that the parent or guardian provides the child with proper education. Number 2. When a child's employment or participation in public and entertainment or information through cinema, theater, radio, or television is essential. Number 3. The employer shall ensure the protection, health, safety, and morals of the child. Number 4. The employer shall institute measures to prevent the child's exploitation or discrimination. Number 5. The employer shall formulate and implement a continuing program for training and skill acquisition of the child. A work permit from the Department of Labor and Employment is necessary for any child to work. Furthermore, the states shall provide non-formal education programs for promoting intellectual, moral, and vocational efficiency. The state shall also prevent the use of minors in commercials promoting alcohol, tobacco, and violence. Article 9. Children of Indigenous Cultural Communities. Under Republic Act 7610, children of indigenous communities shall be entitled to protection, survival, and development consistent with their customs and traditions. They shall also be afforded alternative education systems. The DECS shall also accredit and support non-formal but functional indigenous educational programs. The state shall also give priority to the delivery of health and nutrition to children of these communities, and hospitals and health institutions shall give equal attention to indigenous patients. Indigenous health practices shall likewise be recognized. Indigenous cultural communities, through their duly designated or appointed representatives, shall be involved in planning, decision-making, implementation, and evaluation of all government programs affecting children of indigenous cultural communities. Penalties of arresto mayor in its maximum as well as fines shall be given to those who discriminate against children from these communities. Article 10. Children in situations of armed conflict. Children shall be regarded as zones of peace. They shall not be used in nor be subjected to acts of war. Neither shall the delivery of their needs be hampered by war efforts. That state shall give priority to children during evacuations, accompanied by persons responsible for their safety and well-being. Temporary shelter shall be afforded to the entire family when possible. Children arrested for crimes related to armed conflict shall be detained in a space separated from adults except when detained as a family unit. They shall be given immediate legal assistance as well as immediate notice of arrest to parents or guardians. The child shall be released within 24 hours to the DSWD or any responsible member of the community as determined by the court. If after hearing the evidence in the proper proceedings, the court should find that the aforesaid child committed the acts charged against him, the court shall impose a penalty. The penalty, however, shall be suspended until the child is 18 or for a shorter period as the court may deem proper, after considering the reports and recommendations of the Department of Social Welfare and Development, or the agency or responsible individual under whose care he has been committed. Article 9. Remedial Proceedings. Who may file the case? A. Offended party. B. Parents or guardians. C. Ascendant or collateral relative within the third degree of consanguinity. D. Officer, social worker, or representative of a licensed child-caring institution. E. Officer or social worker of the Department of Social Welfare and Development. F. Barangay chairman. Or G. At least 3 concerned responsible citizens where the violation occurred. The offended child shall immediately be placed into the care of the DSWD. His name may be withheld from public until the court acquires jurisdiction over the case. Cases involving violations of this act shall be heard in the chambers of the judge of the regional trial court, duly designated as juvenile and domestic court.